If you don't interrupt me.
No, I filed a motion to proceed pro se and to be admonished. I also filed a motion for recusal of the court.
I know.
Proceeding pro se.
This is yes or no.
No.
On February 17th, 2026, Michael Wayne Osborne appeared before a Texas judge facing charges of burglary of a building in Jefferson County, a state jail felony that had been enhanced to a second-degree felony due to his prior criminal convictions. Osborne had a 1997 forgery conviction from the same court, and after that conviction became final, he was subsequently convicted of unlawful possession of a firearm by a felon in Orange County, Texas. These prior convictions meant that what would normally be a state jail felony punishable by 6 months to 2 years was now being prosecuted as a second-degree felony carrying 2 to 20 years in prison. Osborne was in jail, unable to post bond, and had been appointed a public defender to represent him. But when he appeared for this hearing, Osborne had filed multiple motions that revealed he had no intention of working with his court-appointed attorney or cooperating with the proceedings. He had filed a motion to dismiss his counsel, a motion to proceed pro se, meaning he wanted to represent himself, a motion to recuse the judge, and a motion to quash the indictment. The most explosive of these motions was the recusal request, in which Osborne demanded that the judge step down from presiding over his case. The reason? Osborne claimed to have a grudge against the judge dating back 8 years to a previous case where he believed the judge had wronged him by refusing his plea agreement and failing to give him proper credit for time served. But Osborne is about to realize that judges cannot be removed simply because a defendant doesn't like them or disagrees with how they handled a previous case.
Well, if you don't recall, you should remember.
First of all, back time, I don't have a... Number one, you're so wrong.
Time last court setting to get all of this information, and he told me today that he didn't want me on this case.
Church and it's awful. You stand in front of the judge and he's no fun. When I saw people sitting down, they looked on.
Okay. We've got an indictment here, 25 CR 1791, that accuses Michael Wayne Osborne, that's you?
Yes.
Correct. Of the state jail felony of burglary of a building, and it also alleges that you have a prior forgery conviction out of this court in 97. And then paragraph 3 goes on to allege that after that 97 conviction of forgery was final, you committed the offense of unlawful possession of a firearm by a felon and were convicted of that in Orange County, Texas. So this state jail felony then becomes punished as though it was a third or second, because they're in sequence. If you don't interrupt me, okay? That's rude, and we can't all speak at one time. Hold on, you're going to get a chance to speak. So this appears to be indicted as a state jail felony, though it's punished as a second-degree felony if found guilty. And
Recusal.
I know.
No, I filed a motion to proceed pro se and to be admonished. I also filed a motion for recusal.
I know. I just asked you a question, sir. Just, are you able to hire your own lawyer, though? I'm just
proceeding pro se.
This is yes or no. This isn't a hard one to figure out, sir. Are you able to hire your own lawyer if you wanted to, though?
No.
Yeah, okay, you're because you're in jail and you don't have an income. All right, you're indigent then.
Yes.
Right. Okay. All right. We're going to take these one at a time. Motion to dismiss counsel here. Why do you want that? Because this lady is here to represent you. you believe you could represent yourself better? Is that what you think?
Well, I'm sure you're aware, Judge, that I've been through this before and I represented myself. I have no problem with it. See, it's a barrier of communication when she offset this case and didn't network with me. Then I didn't want this presiding court even to adhere to the alleged offense. I don't want to be tried before this court, not with you presiding.
Why is that?
Well, if you don't recall, you should remember 8-9 years ago, you refused my agreement, and then you still sentenced me, and you never gave me my back time. And I don't see how we can entertain this today when I filed a motion to recuse and you still entertaining the case.
Yeah. Well, first of all, back time. I don't have number one. You're so wrong, because back time is not in this court's discretion. It's law. If you have time credited, you have to be awarded to this. And the court has never in 20 years denied back time that is allowed by law. So that doesn't make any sense there.
The hearing began with Osborne immediately challenging the judge's authority to preside over his case. When the judge asked why Osborne wanted to dismiss his court-appointed attorney, Osborne responded that there was a barrier communication with his lawyer and that he didn't want this presiding court to hear his case. The judge asked directly, "Why is that?" Osborne's response revealed the grudge he had been nursing for nearly a decade. "If you don't recall, you should remember 8 years ago you refused my agreement and then you still sentenced me and you never gave me my back time." This accusation struck at the heart of Osborne's grievance. He believed the judge had treated him unfairly in a prior case by rejecting a plea agreement, sentencing him anyway, and failing to award him credit for time served while awaiting trial. The concept Osborne was referring to, back time or jail time credit, is governed by Article 42.03 of the Texas Code of Criminal Procedure, which requires that defendants receive credit toward their sentence for any time spent in custody before conviction. This is not a discretionary decision by the judge. It is a mandatory calculation required by law. The judge's response was immediate and pointed. First of all, back time is, number one, you're so wrong, because back time is not in this court's discretion. It's law. If you have time credited, you have to be awarded to this, and the court has never in 20 years denied back time that is allowed by law, so that doesn't make any sense there on that one. This was a devastating rebuttal because it exposed that Osborne's entire grievance was based on a fundamental misunderstanding of the law. Judges do not have the power to deny defendants credit for time served. It is automatically calculated by the Texas Department of Criminal Justice based on jail records. If Osborne felt he had been shorted on his time credit, the problem was not with the judge but with the administrative calculation process, and there are specific legal remedies available through the prison system to correct such errors. By blaming the judge for something the judge had no control over, Osborne had revealed that his motion to recuse was not based on legitimate legal grounds, but on personal animosity stemming from his own misunderstanding of how the criminal justice system works.
Number two, you can certainly represent yourself at any time if you wish, so long as you are completely aware and appreciate that the people who represent themselves pro se generally are not successful because attorneys are more profoundly aware of the rules of evidence, the penal code, the code of criminal procedure, and other laws that are used is always a disadvantage. That's why it's a long statement. People who represent themselves have foolish people for their own clients. That was something that was part of the history of law before I was born, because there's not a lot of success at doing that. And when you're not adept at the rules of law, then you can, you have a disadvantage. But you're an adult. You get to make your own choice. If you want to represent yourself, you just have to know that when you represent yourself, you're going to have to follow the rules of law and the evidence and the court of criminal procedure and the rules of criminal procedure and the penal code and the other rules that may come into the trial process. Let's see. And you'll be able to represent yourself if that's what you clearly want. Have you ever represented yourself in any criminal proceedings before?
Well, I'm sure you are quite aware that I have.
No, that's just yes or no. And just play like I haven't had 50,000 defendants in this court.
Wow.
You're going to have to refresh my memory. Go ahead. What have you done? What's your experience in representing yourself?
I start out with, Your Honor, with the fact that I filed motions that the court is not adhering to, and it seems to me that you're depriving me of due process because I don't want this court to preside, you to preside over this case.
Well, when you have good cause, just because you don't want, okay. If you want to interrupt me all day, we can't both speak because when you speak over me, this lady can't take what you're taking down, what you're stating. And it's rude, number one, but it's impossible for her to take what you state. Let me speak, then you'll get an opportunity to speak, okay? All right. Look, the Constitution of the United States does not state you anywhere that you get the choice to make your to have a judge of your wish before you. And you get a judge who is a lawfully presided judge, and that's what.
The judge then launched into a lengthy explanation of the disadvantages of self-representation, fulfilling a constitutional duty established in the landmark 1975 Supreme Court case Ferretta versus California. In Ferretta, the Supreme Court held that criminal defendants have a Sixth Amendment right to represent themselves in criminal proceedings, but courts must ensure that this waiver of counsel is knowing, intelligent, and voluntary. This requires judges to conduct what is known as a Ferretta colloquy, a series of warnings and questions designed to ensure the defendant understands the risks of proceeding without an attorney. The judge then asked Osborne about his prior experience representing himself. Osborne responded, "I'm sure you are quite aware that I have," suggesting he had done this before in the judge's courtroom. The judge's response was both humorous and pointed. "Well, no, that's just yes or no. And just play like I haven't had 50,000 defendants in this court. You're going to have to refresh my memory." This comment underscored an important reality. Judges see thousands of defendants over their careers and cannot be expected to remember every individual case, especially from 8 years earlier. Osborne then attempted to return to his motion to recuse, claiming the judge was depriving me of due process by refusing to step down. The judge's response addressed a fundamental misunderstanding about judicial recusal. Under Texas law, specifically Rule 18A of the Texas Rules of Civil Procedure, which applies to criminal cases through common practice, judges may recuse themselves when there is good cause, such as personal bias, financial interest in the outcome, or family relationships with parties. However, the judge explained, "The Constitution of the United States does not state anywhere that you get the choice to make your judge of your wish. You get a judge who is a lawfully presiding judge, and that's what you get. Just because you don't like me to preside over your case, that's not enough." This was a critical civics lesson. Defendants do not get to shop for judges they like or remove judges they disagree with. The judicial assignment system exists precisely to prevent parties from manipulating which judge hears their case.
Just because you don't like me to preside over your case, that's not enough to grant your wish. Then I have a motion to quash an indictment here that you have filed, and can you summarize the reason that you filed this?
That was predicated, Your Honor, because it fails to state, I don't have a document, probable cause, information, or anything to go by. And first of all, I never entered any building.
No, but that's not, that's what we deal with at trial, but the four corners of the indictment, what's
All
wrong?
four corners, it doesn't meet the element of burglary of a building.
What does it fail to state? Because it states,
giving notice that I fully entered, partially entered, something to that effect, in which that would probably give me the benefit of defending myself against.
okay, in summary, this states the elements of the penal code of burglary of a building clearly in this paragraph that on or about October 15th, 2025 in Jefferson County, Texas, with the intent to commit theft, you intentionally and knowingly entered a building or portion of a building not then open to the public without the effective consent of the owner. Those are the elements of burglary of a building. Anything else? What was it missing? What was the element that's missing that's in the penal code that you're saying?
Into the building.
Oh, but it's an allegation, sir. It's not, that's what we do at trial, it alleges, it's what the allegation is. That's why we have a trial, and that's why you get to present evidence, the state presents evidence, and a jury makes a decision. Everybody who pleads not guilty contests what it says. The question is the four corners of the indictment. Does it allege the allegations that are required for the commission of a crime? And it does. That's why
Osborne then attempted to argue his motion to quash the indictment, claiming that the indictment fails to state the necessary elements and that he had no document, probable cause, or information or anything to go by. He also made a factual claim that would become important later. First of all, I never entered any building. The judge immediately corrected this misunderstanding, but that's not what we deal with at trial. Your question is the four corners of the indictment. What's wrong with it? What does it fail to state? This distinction is critical to understanding how indictments work. Under Article 21.01 of the Texas Code of Criminal Procedure, an indictment is a formal written accusation charging a person with a criminal offense. The test for whether an indictment is legally sufficient is not whether the allegations are true, that is what trial determines, but whether the indictment properly alleges all the elements required by the relevant criminal statute. The judge read aloud the relevant portion of the indictment. On or about October 15th, 2025 in Jefferson County, Texas, with the intent to commit theft, you intentionally and knowingly entered a building or portion of a building not then open to the public without the effective consent of the owner. The judge then asked, what was it missing? What was the element that's missing that's in the penal code that you're saying? Under Texas Penal Code Section 30.02, burglary of a building requires proof that a person, 1, without the effective consent of the owner, 2, enters a building or habitation, 3, with intent to commit a felony, theft, or assault. The indictment alleged all three elements: entry without consent into a building with intent to commit theft. Osborne's response revealed his fundamental confusion about what an indictment is. But that's an allegation, sir. The judge patiently explained, it's what the allegation is. That's why we have a trial, and that's why you get to present evidence. The state presents evidence and a jury makes a decision. Everybody who pleads not guilty contests what it says. The question is the four corners of the indictment. Does it allege the allegations that are required for the commission of a crime? This was a crucial distinction. An indictment does not need to prove the defendant committed the crime. It only needs to properly allege that if the facts stated are true, they would constitute a crime. The burden of proof comes at trial, not in the indictment. The judge denied the motion to quash, stating it properly fits the elements of the indictment. Osborne had filed the motion multiple times, apparently not understanding why it kept being rejected.
So that's denied.
Yeah.
The motion to quash is denied. It does
That's a copy of that.
properly fit the elements of the indictment, and you filed it more than once here. There's a motion to quash on December 19th. What's the difference?
I never got an answer. This is why I refiled it.
That's why we're here today. The motion is denied.
This
let's
is
see,
nothing but
wanting to
criminal
advance pro se. Well, you're so rude. Interrupt the court. I told you have a chance to be heard, sir. You can't help yourself. How many times well, we learned that in second grade. Not that our teachers would scold us. Don't be rude to others and don't speak over others. You're going to get a chance to speak. Okay, wanting to advance pro se, that's granted. You're going to get that. That's all. Now, that's all I have here. The motion to quash, hold on. The motion to quash is denied. The motion to proceed pro se is granted. That's another pro se, that's granted. Motion to dismiss counsel, that's granted. Anytime you want to change your mind on that, though, I would urge you, let me know so a competent attorney can be appointed to represent you. Does he file something? I'm sure he's not able to pay and Mr. Osborne is deemed a transient. Is there something in here that shows he's indigent, though, so that we can appoint somebody? There is an affidavit of indigence that was never signed by you. That needs.
The judge then addressed Osborne's repeated interruptions with a sharp rebuke that highlighted one of the fundamental problems with pro se defendants. They often do not understand or respect courtroom decorum and procedure. The judge stated firmly, "You're just so rude. Interrupt the court. I told you have a chance to be heard, sir. You can't help yourself. We learned that in second grade. Our teachers would scold us. Don't be rude to others and don't speak over others. You're going to get a chance to speak." This admonishment was not petty. It reflected a serious problem. When parties speak over each other in court, the court reporter cannot accurately transcribe what is being said, which means there is no reliable record of the proceedings. This can create serious problems on appeal if a defendant claims something was said or done that does not appear in the transcript. More fundamentally, courtroom decorum exists to ensure orderly proceedings where all parties can be heard and understood. Pro se defendants often struggle with this because they view court proceedings through an emotional lens rather than understanding the procedural framework that governs how cases are conducted. The judge then granted Osborne's motion to proceed pro se and his motion to dismiss counsel, stating, "Anytime you want to change your mind on that, though, I would urge you let me know so a competent attorney can be appointed to represent you." This was an important safeguard. The judge was making clear that Osborne's waiver of counsel was not irrevocable and that he could request an attorney at any time. However, the judge then identified a procedural problem. The court file contained an affidavit of indigence, a form that defendants must complete to establish that they cannot afford to hire their own attorney and therefore qualify for court-appointed counsel, but Osborne had never signed it. The judge noted that it appeared a magistrate judge, Judge Duran, had gone over the form with Osborne, but you wouldn't sign it or fill it out. This created a practical problem. If Osborne later changed his mind and wanted an attorney, the court would need to stop all proceedings to have him complete the indigence paperwork before appointing counsel.
I requested one immediately.
Okay, but here's the deal. Anytime you want to change your mind, which is the right you have under the Constitution to have a lawyer represent you, what would happen, we'd have to stop everything we're doing and get you to fill out an indigent form. If you fill out an indigent form now, it's in there ready to go in the event you change your mind.
Okay.
But it's your call if you don't want to do that, but it stalls everything, I would urge you to do it just to have it as a safety. Okay, sir?
But one thing, did you get the motion for an investigator? I sent that as well.
I'm looking at all of this and okay, motion to dismiss. There's no investigator in that. There's something about, this says yes from what that would cause this court.
Couple of calls and information if at all possible.
Yeah, okay. If Greg, can you make just a copy? soon as possible. At any time you want to change your mind, let me know immediately so we can get somebody in here, okay? Yes, sir. All right, sir.
Thank you.
All right, thank you.
Michael Wayne Osborne chose to represent himself on a burglary charge carrying up to 20 years in prison, and it's going poorly. The judge patiently advised him to complete an indigence form as a safety net in case he changed his mind about needing an attorney, and warned him that pro se defendants generally are not successful. Osborne's missteps were numerous. He filed a baseless recusal motion rooted in an 8-year grudge built on a legal misunderstanding, repeatedly tried to quash his indictment using factual arguments that belong at trial, not in pretrial motions, and constantly interrupted the judge, damaging his own credibility in the process. His request for a court-funded investigator will likely be denied, as that right doesn't extend to defendants who voluntarily waive counsel. Despite Osborne's rudeness and frivolous filings, the judge remained fair and methodical throughout. Unfortunately for Osborne, patience from the bench won't save him from the consequences of going to trial alone on a serious felony charge. And when the inevitable guilty verdict comes and he faces a lengthy prison sentence, he will have no one to blame but himself. Let us know if there's a case or courtroom interaction you'd like us to cover in the comments below. Thank you for watching, and don't forget to subscribe and share so we can help foster a more informed society.